Good afternoon, everybody. Welcome to today's Emerging Issues Workshop on the Me Too movement. For those of you who don't know me, I'm Edward Iacobucci. I'm the Dean of the Law School here. I'd like to begin by acknowledging the land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we're grateful to have the opportunity to work on this land. So the Me Too movement, as everyone here knows, has sparked conversation and action that is long overdue. International Women's Day seems an especially fitting moment to further the conversation. We're grateful to our speakers for being here and sharing their valuable insights. Conversations like this not only, I think, help us think about a path forward, but are essential in keeping these issues front and center in public discourse. So it's wonderful to see so many faculty, staff, students, community members, alumni in the room today, and many more joining us on a Facebook broadcast. At this point, I'd like to thank the students and the staff who helped organize it, and I'm going to turn it over to one of the students, Emily Young, who will describe the sort of fundraising aspirations today to support the Barbra Schlifer Clinic. So with that, welcome, and Emily.
Hi everyone, happy International Women's Day. Before the event starts, we wanted to let you know that while this is an emerging issues workshop, it's also being done in conjunction with an annual fundraiser that the community engagement group at U of T runs. And this fundraiser goes to support the integral services that the Barbra Schlifer Commemorative Clinic provides. And today we have DEEPA MATTOO, the legal director of the clinic, on our panel, so you'll hear more about her important perspective. Just to give a brief overview of what the clinic does, it provides counseling services, legal services, and cultural and language interpretation services to women who are at risk of experiencing violence or have experienced violence. And the Barbra Schlifer Commemorative Clinic has helped over 60,000 women since its inception. So it's a very, very important cause. There are two ways that you can donate today. At the end of the event, we will have buckets positioned near the exit, and feel free to drop any cash donations that you might want to give into there. We also have an online fundraiser ongoing, and if you would like to donate online, maybe you don't have cash, which we completely understand, the link is right up here. And just be aware that because it is a bit.ly link, it is case sensitive. So fair warning that there is a capital H and a lowercase h in there. So if you do go to that link, make sure you're getting it right, and there you can donate as much as you want by credit to debit card. So without further ado, I'll pass things on to Professor Martha Schaefer, who will be moderating the panel discussion today.
Thank you, Emily and Dean Iacobucci. So the term Me Too, or the hashtag as it's now become, is actually not new. The term was coined in 2006, so over a decade ago, by Tarana Burke, an African-American woman, to draw attention to the prevalence of sexual assault against women and girls, and in particular, to the sexual violation of women and girls of color. Since the fall of 2017, when it became associated with the downfall of media mogul Harvey Weinstein, Me Too as a hashtag has gone viral. And along with the hashtag Time's Up, Me Too has come to symbolize a movement in which women, in unprecedented numbers, have come forward to publicly share their experiences of sexual harassment and abuse. The Me Too movement is in fact unprecedented in many respects. It is unprecedented in terms of the sheer numbers of women who have come forward, and in terms of the breadth of the movement. What started in Hollywood has spread to the music industry, the media, the theater, the restaurant industry, the academic world, sports, and politics. Me Too is also unprecedented in terms of its consequences. Women's accounts of sexual assault and harassment are being believed, they're being taken seriously, and men in positions of power are being held accountable for their actions. Me Too and Time's Up are important social and political movements, and they raise a host of challenging questions. Sexual assault, sexual harassment have been around for a long time. Why has the Me Too movement taken off now? Will the movement have staying power? Does the movement address the harassment and violence all women experience, or has it focused primarily on women with a certain degree of status and privilege? For lawyers, the movement also raises challenging questions about the law and the legal system. Why are so many women turning to the media to tell their stories of harassment and violence rather than going to the legal system? What are the risks to survivors of using the media to share their experiences of sexual harassment and violence? And what are the options for redress within the legal system? To discuss these and other issues that arise from the Me Too movement, we are fortunate to have a panel of 4 speakers who I have the pleasure of introducing. At my very far left, at the end of the room, we have Sarah POLLEY. Sarah is an actor and a filmmaker who has written about sexual assault, including a recent piece in the New York Times. To Sarah's right is ALEXI Wood. ALEXI is a founding member, a founding partner at St. Lawrence Barristers, LLP. She acts for clients on tort matters, including issues related to health law, defamation, and privacy. ALEXI is also an adjunct professor here at the Faculty of Law at U of T, where she teaches advanced torts. ALEXI is also counsel for the 4 actors who are suing Albert Schultz and the Soulpepper Theatre Company. To ALEXI's right is DEEPA MATTOO. DEEPA is a passionate defender of women's rights to safety, access and justice, and self-determination. DEEPA is the Director of Legal Services at the Barbra Schlifer Commemorative Clinic. She's also an adjunct professor at Osgoode Hall Law School and the co-director of the Feminist Advocacy Program. And finally, we have, or will have, Jonathan Lisus. Jonathan is tied up in court. Jonathan is a fellow of the American College of Trial Lawyers and has a national trial and appellate practice. His areas of expertise include commercial law, constitutional law, criminal law, professional liability and discipline, and defamation. Until recently, Jonathan was representing Patrick Brown in his lawsuit against CTV. So the format of today's session. The format of today's session will be the following. Our panel will begin by sharing some thoughts on the Me Too movement, and then we will open up the floor for discussion. As this discussion is being broadcast over Facebook, we will have a microphone circulating around the room, so when you ask questions, please make sure you speak into the microphone. So perhaps we can start by asking the question, how do you understand the Me Too movement, and why do you think it has taken off now? Anybody who wants to begin?
We're all being so polite and Canadian. I think, so one of the things that I think is important to observe when we're talking about the Me Too movement is that at this time in history, the Me Too movement didn't start in a vacuum. And I think that's one of the things that's important to address. There were, at the same time and preceding the Me Too movement as well, several other movements that came forward, all with the same idea of saying the status quo. Hello. The same goal of saying that the status quo is not okay. What we've been accepting as the status quo is not okay for a variety of reasons, and this happened in a bunch of different contexts. We saw and this is not an exhaustive list by any stretch, but there was the Black Lives Matter movement. There's been a lot more discussion about mental health, about transgender issues, about Aboriginal issues. All of these discussions were coming forward, all, as I said, with the goal of saying the status quo is not okay, and we're not going to just accept it the way we might have in the past. And so in that context, the Me Too movement came about at sort of the same time that we were seeing some of these other emerging issues happening. And so I think it's important to remember that the Me Too movement doesn't happen in isolation, in a vacuum, but needs to be seen in the context of some of these other issues that were happening at the same time or preceding it slightly as well.
And if I can add to it, and thank you for bringing up Trana Burke's name, because I think it's kind of important to remember that the Me Too, the way we are witnessing it right now, is just a progressive development of what was something started almost like a decade back, right? So it's not something which has just out of the blue started. And for the people like myself who have been working with the issue of violence against women, for definitely it's something we are really looking at, witnessing, and also looking at the impact of it on our services. But at the same time, it's not something new for us. Like, these disclosures are not new for us. This information that sexual assault and sexual violence in our society is so pervasive is not new for us. Violence against women is not new for us. So I want to kind of remind all of us in the room that violence against women is not new, and the sexual assault cases are also not new. So Barbra Schlifer Commemorative Clinic, the clinic is named after a woman who was sexually assaulted and killed on the night of her call to the bar. And for the people and the people from the legal fraternity here in the room, we can take a moment to reflect on that this clinic in itself comes out of a very sad situation of a violence against women and sexual assault. So it's not, definitely not new, as Alexi is saying, but something also it is important to kind of think about is that what is happening with, what's the impact, what is really happening, and whose voices are we really hearing? So Chidminda Nzogozi, who I think some of us know about her work, and she speaks to a lot of issues of women of color, she kind of talks about this, the fear of single story, which I think we should also always remember when we talk about violence against women in the context of a digital movement like Me Too. Whose stories are being told, whose stories get told, who can access that resource to tell those stories. I think all of those factors need to be kept in mind when we are talking about this.
I would say that while sexual assault and sexual harassment are obviously not new, I think what is new is this mainstream reevaluating of our past experiences as women, so that women who are not political, who are not connected to institutions like this one, are looking at things that have happened to them in the past that they may have thought was a kind of part of life that they had no recourse for or were normal, and are looking at them in a very different way. And I've also seen, to a smaller extent, but I think a really important extent, men doing the same in terms of reevaluating their past behavior and thinking of what had been normalized, now seeing it in a different frame. I don't think that we're in a climate right now where we can, where we're hearing those voices as much. I'm hoping at some point we will, because I think it's a really important part of the conversation to hear men reflecting on how they've behaved in the past and looking at their behavior instead of this being a completely female-centric movement. I think it's about us all looking also at our complicity. I mean, I think that there's also a lot of necessary finger-pointing going on, but we also have to look at ourselves. I think this environment, this climate, this kind of normalized behavior existed because a lot of us, and I include myself in this, while we were experiencing sexual harassment, you know, in the film industry specifically, we were also standing by and watching it happen almost every day. And there didn't feel like there was a recourse. There didn't feel like there was anything one could do. And I think that that complicity is, at least in my industry, I'm really seeing a shift. And the question for me is this loud enough and mainstream enough that it's going to affect people who are much more vulnerable? So, you know, I've been reading a lot of things about domestic workers and hotel staff, and does this trickle down, and how does it trickle down to people who actually are most vulnerable and most need to know there's something that they can do? And is that, when does that sort of conversation reframing happen? So hopefully it shines a light on the issue, but I'm kind of curious to see where it goes beyond the film industry, because I do think that there is a certain amount of people feeling more empowered now, at least in my industry, than there was before.
So I missed the question, but I've been able to gather that it's what are your thoughts or your views on the movement. And I have to say that I have found the hashtag #MeToo movement to be a very fascinating and in some ways, you know, wrenching learning experience and it has been a learning experience to see this evolve. I mean, I of course agree with DEEPA that abuse of power is not new. It's the oldest game in the world, right? It's as old as humanity, abuse of power and exploitation. But the movement, the hashtag movement, I find particularly interesting because I evaluate it or try to understand it from a few different perspectives. One of them is the perspective of a father of a second-year female law student at this school, and about to go into the practice of law, which is an environment that has power structures and authority structures. But it also occurs to me, as I've sort of watched it evolve, that this is part of a larger movement, I think, in which authority structures, power structures are being called into question, are being challenged. Gaps in the way or the ability to call these power structures to account are being filled. And I think of the movement on a kind of a spectrum. And if you reflect back, you see this expressed in the Arab Spring movement, challenge to political authority structures by a digital movement. You see it in the way in which policing has been challenged by the ability of citizens to actually record and prove the existence of the abuse of police power and police authority. Just think of how the ubiquitous device that you have in your hand has changed policing and has changed the criminal justice system. You know, the Rodney King episode almost 20 years ago, maybe more, was a freak. Someone happened to have a video. Now you look at the impact of digitalization on policing, which is a very significant power structure in society, and all of a sudden citizenry have real power because you've got a camera, and you've got a camera that you can project out to millions of people. You don't have to persuade a news outlet to run it for you. And so I try and understand and evaluate the movement in that context, that this is a movement that is about challenging power structures, that is about responding to gaps in the existing structures, civil and criminal, about how we deal with these things. And I do believe that it's very much a generationally driven movement. It's not finding expression in a particular generation, but I think its origin is generation and its origin is digital. And it's about information and access to information.
So perhaps we can turn to a question I think comes out of some of the comments that have been made, which is, why is this playing out for the most part in the media, or maybe I can put it, the court of public opinion, as opposed to courts of law? And I think for lawyers, that's a particularly important question. And then related to that, what are the dangers of this all playing out in the media as opposed to in courts of law?
Well, I mean, most simplistically, nobody was going to take Harvey Weinstein to court, right? You would have been crazy. So I think, like, from my perspective, as someone outside the legal profession, the specter of being on a stand in a criminal trial accusing someone of sexual assault is not a pretty one. And it's not one that most people would choose to go into if they have all the information. So, I mean, there's a lot of lawyers in the room and a lot of people studying law in the room, but my experience has been, and I've asked a lot of criminal defense lawyers this question, would you advise someone you loved to come forward in that kind of case? And almost 100% of the time the answer is no. And almost 100% of the time when you ask the question, should anything be changed within either the system itself or the behavior of the actors in the system to make this easier on complainants, the answer is also no. And when prodded about that contradiction, I get extremely emotional responses from people who are trained to be rational. And I'm fascinated by how, and I'm really curious to hear a discussion about this later if anyone wants to talk about it, but just how legal professionals hold that contradiction with ease, but then so emotionally when provoked about it. And so, yeah, I think that it's a matter of being smart. You look at how you can be savaged on a stand, and then you look at the media, which is, yes, unreliable, and yes, self-serving, but a lot less scary. And none of this would have been happening without the media. And I was very cynical about the idea of people going to the media. I was like interviewed about it really just before all this broke, and someone said, I had talked about a conversation I'd had with a judge where I said, you know, given that most people lie when they've experienced sexual trauma in some way, whatever you want to call a lie, whether that's blocking out information, not remembering things accurately, whatever could be, you know, accused of being an inconsistency, given that that is just the case, what do you do? And she said, well, perhaps a courtroom's not the best place for you then. And I said, well, given that most people do that when they've had this experience, what is the best place for you? And she said, I don't know. And then I got interviewed about this on Canada and with Jesse Brown. He said, the media is the best place for you. And I thought, no, that can't be right. It can't be like vigilante justice. I'm not okay with that. I want to see a process. But then, to be honest with you, I've shifted on that, watching the New York Times, how long they worked on that story, how for years and years people have worked on that story. I'm not seeing what the media is being accused of very often. So yes, I'm sure there are cases where the media is being irresponsible, but generally I see a lot of process. I see journalists not wanting to get it wrong, doing due diligence, sitting on stories, deciding not to publish stories. Anecdotally, with journalists I know, they don't want to go forward and be the one to wreck this. So I'm actually seeing a lot of responsibility on the part of journalists. I'm sure there will be exceptions to that rule. But again, I think it looks a lot less scary to survivors of sexual assault to go to the media than it does to go through a court system. Now, what ALEXI's doing is obviously, you know, opened up this third way, which is really exciting, I think, for a lot of people to see. Again, outside the legal profession, it's something that wouldn't have occurred to most people. And again, I guess my question is just about access, and if you don't have the right people to talk to, how aware are you going to be of these other options other than the media or the criminal justice system?
I'm happy to pick up on that. I think one of the things too from your question, Professor, is implicit in that question is this assumption that there's sort of the criminal system or the media, and I think that really was the assumption until quite recently. And I think, pulling in something Jonathan said too, when you were answering your question, you started talking about abuse of power. And one of the things that I find really fascinating to explore in this is the power dynamic that exists and how the Me Too movement has enabled has enabled in various ways women to regain power. And that's an incredibly important thing. They've had power taken from them for so long, and now there are options and avenues to regain some of that power and control. So when looking at ways to express the Me Too movement and to address wrongs, I think one of the things that we are now able to do is look at various options. It's not a sort of binary, am I going to go to the police and go through the criminal justice system or not? And I think we are happily moving away from that discussion of, well, but you didn't go to the police, did you? And you know that there's a sort of implicit assumption in that if you didn't go to the police, or if a woman chose not to go to the police, that somehow her claim isn't real. She doesn't have a real case because she didn't go to the police. And to your point, you know, she may choose to not go to the police for a variety of reasons. It has nothing to do with the strength or merits of the case. It's just a choice. And again, it's that choice, that power, that control that's so important. So when looking at this issue, there are many different options that exist. There's media alone. There is the criminal justice system. There is civil litigation, which is an option. If it's an internal issue within an employment issue, you can internally deal with it through HR policies, through your department. and none of these is perfect. There are pluses and minuses to each option. No option is a silver bullet, and no option is terrible. And I think that's part of the discussion that has to happen. Each woman who wants to bring one of these claims gets to make her own choice. For whatever reason she chose that path, that's her choice. She has, with capable counsel, with assistance through a variety of ways, women can see what these options are and then make that choice that best suits her objective, her story, and her goal. There's other options. There's human rights tribunals if it's in an employment context. There's a whole bunch of different options, and each one needs to be explored and weighed. And I think one of the things for me that I enjoy about discussing those options is that it all comes back to the ability for women to exercise that power and control, which has been something that's been taken away from them for so long.
Yeah, I think you pretty much have summarized it. The only other piece which I would probably, maybe going back to the question, think about is that there is media and then there is social media, right? So we are talking about two different pieces here. Definitely, there is a power in telling your story or telling your experience in the way you want to tell it, rather than someone telling you this is how, this is all what you can talk about, and boxing you into, you can only talk to me about this incident this way, and this is how you tell your story. You are actually controlling that process if you choose to tell that story in your own words, when you want to tell it, how you want to tell it. If all of that is under your control, then you do feel that you were able to tell that story the way you wanted to tell it. In terms of the risk which is associated with it, yeah, most definitely, there is risk. But then what process do we not have risk? So you have to kind of think about and weigh what are we talking about. So for some women, as ALEXI is saying, if their choice is just to tell the story and warn other women of this situation, then that's about it. Then they're not necessarily engaging with the legal system. They are not necessarily looking for those options. My only thing is having avenues for women to make those choices clearly, whether I want to engage with the legal system tomorrow, and if I engage with the legal system tomorrow, what does this tweeting means right now for me? What does telling this story on a blog means to me? Because if she doesn't know what that means to her tomorrow, what that disclosure would do to her case tomorrow, I think then she's not acting with full and complete options given to her. And that's the only thing I would say that, and that's for everyone and anyone, right? Like, I do a lot of tweeting. I am on most of the social media platforms, not as a clinic myself. And as a lawyer, I'm trained to think about what would this mean? Who would read it? How they would read it? What would be the perception of it? So thinking about those in a legal institutions and legal frameworks, if you decide and choose to engage with them, you have to think about it. If you're just doing it on social media, it's pretty much how women have kept themselves safe for years and centuries. And mothers or grandmothers or sisters, cousins, that's how we have kept safe all these years. That's how we negotiated safety, right? We told each other to watch your back, and we talked to each other. We all, growing up, have done that, right? We just didn't use hashtags at that time because there were no hashtags. I come from the grassroots movement, right? So I am the one who has got placards and been on the street and organized that way, right? So I feel this is an extension of that grassroots organizing that now is coming to the digital age, and organizing has become easier because you can use your phone to organize rather than going out in the street in this weather. So, so thinking about it, what is your goal and what is your aim? So I completely agree with ALEXI. So at the clinic, we do independent legal advice for sexual assault survivors. It's a pilot project, which with the new announcement, hopefully will continue for coming years. And that's exactly what the goal is of that project, to meet women where they are at and work with them the way they want to work with their case. Rather than telling them, you should do this, it's about what do you want? What is the outcome you're looking for, and what is best suited for you?
So, to return to the question about the media and to pick up on what DEEPA said, I think we have to think about what exactly we mean when we say the media, because the media is not traditional anymore. there is media as we traditionally understood it, and there is social media. And we all can participate in social media, and it can be very powerful. I believe the line between traditional media and social media is becoming increasingly blurred, and it's hard to know and see where one ends and the other begins. All media outlets utilize social media. They all Twitter and they all tweet and have Facebooks, and you get twittering and tweeting from trials as they occur, and the boundary between media and social media, I think, is becoming increasingly collapsed. There's no question that the movement, #MeToo movement, is a great leveler. It's also very, very powerful. I think that we all have to, at the same time, and pick up on what Sarah said, remind ourselves that there are standards for responsible journalism out there that the Supreme Court and other courts have articulated. And the standards for responsible journalism govern the manner in which journalists are supposed to walk that line between the world of social media, which is essentially unregulated, and the engagement of that world and its content in mainstream media. And I believe that that is one of the challenges that we as a profession, and I include all of you in that we, you're all going to be lawyers, you're all going to deal with questions about the media, about the way in which media, your cases, your clients' interests, find their way into the media, mainstream and social media. It's very easy to have a very large reach about your client's interests with social media. And that's something that we're all going to have to, I believe, play catch up to, whether you're counsel in court and your client or you or others have been tweeting about your case. There are many trial judges who won't necessarily see that the same way you do. There's juries who are going to be influenced by that kind of conduct. And so I applaud the enthusiasm and the euphoria around social media and #MeToo. It behooves all of us as lawyers who are going to deal with clients, and many of them who are alleged to have done unpleasant things that you have a professional duty to represent before the court, to figure out and balance how you're going to walk these lines. And if you're representing a victim or a plaintiff, you should understand what DEEPA is saying about how social media can really redound to your client's detriment in a subsequent proceeding, whether it's civil or criminal. And so I want to sound a little bit of a note of caution here, because there is a great deal to commend the movement and the good that it has done. I think that we have to discipline ourselves as counsel and as lawyers. And it's not just advocates. You will be, those of you who go into business law will deal with clients who will have their interests affected by social media and tweeting, etc. And you're going to all have to walk that line in some form or another. I guarantee you it's going to come across your desk.
So of course the Me Too movement has its critics. And one of the concerns that is raised against the Me Too movement is that there's a lack of due process, that men are, they lose their jobs, they lose their livelihoods when there's really been no fair procedure. Everything has been done in the court of public opinion as opposed to with the safeguards of a court of law. So I'm curious to hear your responses to that. And I'm also curious to hear your responses to concerns I've heard raised about backlash, and in particular about the risk of complainants, survivors who come forward and use the media facing defamation suits for the allegations that they raise.
I feel like I had a knee-jerk reaction when there was a slew of people suddenly fired, and we were hearing about it in the media the same day, and I had a sort of knee-jerk thing of, oh no, like this has gone off the rails. And then I kind of looked deeper into some of those cases, like Matt Lauer, where I thought, oh my God, we just found out about this how many days ago, now he's fired. And you realize actually there's an investigation that's gone on for months and months and months and months and months. So the fact that we're hearing about it the same day it's happening doesn't actually mean it's happening that same day, which is probably obvious to a lot of people. But I think when people are receiving it that way in the media, it feels as though things are happening much quicker than they actually are. And again, I'm curious about the idea of due process. And again, I'm curious to hear people with a lot more legal expertise than I have talking about how much does it actually exist. Just curious about it. Because, I feel like every time that defense comes up of, there's no due process, I kind of look at the processes that have existed for women coming forward, and they don't look particularly good for women, so from the outside. In terms of the defamation stuff, I'm actually concerned about this. I'm concerned about this for my friends and for my colleagues. They're doing a lot of really heroic information sharing right now that is designed to keep women safe, some of which has very practically kept other women safe from situations they're about to walk into. It's happening in a lot of places right now. It's happening in a lot of social media, but it's also happening in a lot of quote-unquote private social media, where people feel like they're sharing only with each other, and in fact, I know of cases where the people who are being accused are actually watching these feeds go by. So I don't think there's enough education out right now about what the risks are. I think we learn a lot about law from American television, and so I don't think we even know what our own laws are, but we've got American defamation law down. No problems. But I think that having that as a resource for people to know exactly what they're risking when they share this information and how would be a great service. I'm always terrified of sounding that alarm bell, because what you don't want to do is shut down something women are doing to make each other safe. So I've alerted a couple of people and then really regretted it, because you kind of think, well, weighing the risk of defamation versus weighing women walking into a really unsafe environment in an audition room or a photography session, I don't know how to do that. So I think it's complicated, but it would be great to know what the laws are in a really, really broad way for a lot of people right now.
Yeah, sure.
Go ahead.
Okay. I just wanted to kind of talk about some stats that I recently read. Plan International Canada did a survey for the first anniversary of the Me Too movement, and they wanted to know what is the impact in the workplaces of Me Too. And they found that 65% of people were responding. For 3,000 people did that survey, and 65% people said that there's a positive impact in the workplaces, like people's relationship in workplaces seems to have improved. So, and there are 68% people saying that it seems men's behavior in the workplaces have changed. So that, to me, says something, that Me Too has impacted our workplaces, although it's a sample size of 3,000, but it still speaks to us about how the accountability through this movement has created some change in the workplaces. I completely agree with Sarah that some of those situations of people getting fired, maybe it was too late by that time, actually, and organizations felt that, this is an impetus, let's just do it, right? Like it took too long coming. And I think this I'm saying cry, this cry for, that assumption of innocence and this cry for due process also needs to be weighed into the fact that that due process and presumption of innocence, all of those things are the terminologies to be used in the court processes and in the legal processes. When it comes to the societal accountability, we are not necessarily bound by that in our societal communication. And what we also have to understand that if our courts are not seeing the reflection of what society is saying and what women are saying, we would see probably change in our legal system. So there will be an impetus created. It will take time. The risk, as we discussed before, for women, for defamation definitely is there, and therefore there should be a proper independent legal advice and proper legal avenues available for women to actually get consultation on those situations, what can possibly cause defamation in what scenario. Because if she's speaking truth, then she doesn't need to be fearful of defamation, right? So we need to remember that the defamation can also only come to bite her if there is something there. If there is nothing there, she doesn't need to be worried about it. So I think the silencing which comes out of it needs to be really watched very carefully, that we don't need to silence ourselves, but at the same time, yes, acting at the side of the caution and being careful and being, because I'm a very passionate human being, and I come sometime watch myself, and especially when I'm speaking in public, I tell people, I'm saying this, but please don't tweet it, right? so I do that. So I know that that all of us need to be careful in this time and age, but at the same time, we need to remember that not every case can become a defamation suit, and not every case can become malicious prosecution and stuff like that. But absolutely, women need to know, and for men, I'm really glad to see the results of the survey, that there is a remarkable change which is being observed, and I think long time coming. It was needed.
I think the due process question is a really important one, and I think it's a very difficult one, because due process means different things in different contexts. Even within the legal system, what you're entitled to by way of due process at an administrative tribunal, as you guys all know, you're not necessarily entitled to at a lesser tribunal, and you will get a lot more in a criminal court. But it really depends on what question we are asking. I won't speak for everyone. I was going to say, I'm sure we've all been shocked at the speed at which people get their comeuppance as a result of a hashtag #MeToo. It can be quite amazing, the speed at which it occurs. And then sometimes that doesn't happen. So if you look at the way TV Ontario dealt with a disclosure, and the way CTV with Mr. Bliss dealt with a disclosure, very different. I'm sure there may well be a backstory, I don't know, to those things. But again, I guess most of you are law students, or all of you. When we talk about due process, I believe that we're really giving expression to a belief that we have, for better or for worse, an adversarial system of justice. And that is true of the civil system and the criminal system. And I believe, as a practitioner in those systems, that although they are imperfect and they have many shortcomings, that they are fundamentally sound for the job they have to do. There's no question they can be improved. But to pick up a comment that Sarah made about think about one of your loved ones, think about one of your loved ones facing a serious criminal charge. Your wife or your brother or your husband or your father. How much due process do you want them to have? A lot, I bet. Think about yourself being charged or being on the receiving end of a lawsuit. How much due process do you want? I bet a lot. And so we live in an adversarial system of justice, which I think had a lot to do with the birth of this movement. An adversarial system of justice often failed people who were abused. What I think we have to grapple with as we move through this is trying to maintain a balance. And you're right, due process in the public forum, and if you're a public figure, or whether you're a television personality or an athlete or a journalist, you probably get some lesser shade of due process, just as you do in the comparable analog in the justice system. But it is important, and we're going to have to work that out as we go through this.
To pick up on that, I completely agree that there's the idea of due process is specific to the context in which we're discussing it. So there's the employment context where somebody may face employment consequences, they may be fired because of something that has come up, because of an investigation that's been ongoing, and companies are going to make employment decisions based on a variety of factors. The reality is we do live in social media digital age, and that information, the companies have reputations, they have a presence, and those companies are going to make decisions for themselves based on a variety of factors. And that's their own internal decision-making process that's going on. Jonathan's completely correct. There's a different level of standard for when you're talking about a criminal proceeding versus the civil proceeding, and absolutely. And that's one of the things when we're talking about the options that are available to women who are wishing to come forward, to remember that. You know, in a criminal proceeding where the issue is not going to be the complainant's evidence and the complainant, that's not the center. The center focus is not the complainant in that situation. And nor should it be in that context. In a criminal system, we're talking about taking away somebody's liberty. And the state absolutely has to be held to a very high standard. That is part of our criminal justice system, and that's a fundamental part of it. It should be really hard to lock somebody up. Yes, we all agree that is a correct statement. So that is one of the issues to be addressed when looking at your option. Going back to what Sarah was saying about defamation, that's a really important aspect of this, and sort of your warning signal to people that you know about what could happen if you start to say something publicly, whether it's in social media or private social media. Defamation, publication for defamation purposes can be just one other person. It doesn't have to be, or you could have a private chat room. That's still publishing in terms of a defamation context. So while I agree at the end of the day, hopefully, you know, defamation law, one of the defenses, of course, is truth. I would still caution somebody, I would be hesitant to say don't worry about it, because people sue for all kinds of things, we know this. They can still bring a claim, and then you're stuck in the situation of having to defend a defamation claim. So these are all factors that have to be worked into your choices and your options. So while truth absolutely is a defense, and if the civil justice system is working correctly, the truth of that will come out and the defamation claim will not be successful, but that doesn't mean that in the meantime someone's had to defend themselves in a defamation suit. So that's always one of the things I try to discuss with my clients, is looking at those options. Yes, at the end of the day, I would hope that we would be found to be successful and we would defeat the defamation claim, but I can't do anything to stop someone from bringing it. I wish I could, but I can't. From a law nerd perspective, so law students, law nerd moment, one of the issues that I think will be interesting to see what happens in this is the new sections under the Courts of Justice Act for the strategic litigation against public participation, or SLAP suits. So great an acronym, but anyway. The SLAP suits, there's a recent enactment in the Courts of Justice Act that prevents SLAP litigation. It's the anti-SLAP provision of this Courts of Justice Act. And what it is meant to do is to, it gives defendants a vehicle to go to court and say, this litigation is brought with the idea of silencing a matter of public importance. So it's designed to be a vehicle for defendants to come forward and say, I tried to bring this matter forward, I tried to address this issue, I now am being faced with a defamation suit, and that defamation suit is a SLAP suit, it's a strategic litigation against public participation, and the Courts of Justice Act provides that there's a mechanism now to have those matters dismissed and to have access to a higher quantum of damages, or of costs, because of it. It's a very powerful piece of legislation under the Courts of Justice Act. Last year, there were 5 cases that were all argued together at the Ontario Court of Appeal that are looking at the parameters of the SLAP legislation. literally any day now, we expect these decisions to come out of the Court of Appeal, and there's some Superior Court decisions, but there is no appellate level decision yet that addresses this aspect of the Courts of Justice Act. Once these decisions come out, then we'll have some appellate level jurisprudence that can help guide us in dealing with this. But it's a really important piece of legislation, and I think as a law nerd, as I said, it's going to be really interesting to see the use of this provision and how it can be used, especially in this type of a context that we're discussing.
Okay, so we will open for questions now, but let's first see if anybody on the panel has anything they want to add, any response they want to make before we open for questions.
I just want to bring attention to two things. One is the After Me Too movement, which it's really worth looking up, aftermetoo.com. It was a symposium that was held in December with a bunch of amazing people doing roundtables on this issue, and they've just come out with their, I think, 9 or 10 recommendations. So it's really worth looking that up and watching the episodes and looking at the recommendations. And also to Elaine Craig's amazing book, Putting Trials on Trial. I just wanted to throw those two things out there.
All right, we are open for questions. The mic is, Emily has the mic. So anybody, questions, comments, thoughts, reactions? Who wants to start?
All right, I'm going to read it because I tend to ramble. We've talked about providing women with choices and alternatives and information to make a fully informed choice about what route to go. And we've also talked about the adversarial system and how it might not be the optimal or even desirable option for many women, especially knowing that sexual assault often occurs in the context of relationships where jail time for the person responsible may not be the solution that the woman wants to see occur. So to what extent should the legal system and legal actors specifically be providing routes for non-adversarial dispute resolution? And to what extent does this risk undermining the seriousness of sexual assault as a criminal offense if people choose non-criminal routes?
I'm always a supporter of more options being made available. As I said at the beginning, one of the things that I think is so important is this ability to have power and control. And so the more options that are made available and the more routes that people can choose, the better. The one thing, and this again would just be a plus and minus, it would be a factor to consider. One of the things that I find, and obviously not speaking for the women in the movement, but I find that you hear a lot of women who are coming forward saying that they don't want to be silenced anymore, that they do want to they want their issues to be public, whether it's because they feel that they need to be public. More often what I hear is that they are being incredibly brave and incredibly courageous and coming forward on behalf of other women. One of the things I hear a lot is that they may not be angry about themselves, but when they hear it about other people, then they get enraged and they're really angry about it, and that has prompted women to come forward. That they're being brave and strong enough to come forward on behalf of others that have had similar things happen to them. So one factor to consider would be, would the non-adversarial system, would something like that just perpetuate a silence, perpetuate the ability for these matters to be dealt with in private where the discussion isn't being had in the public forum? And for some people that may be what they want. They may want to choose that option and have it addressed privately for a variety of reasons. But that is certainly one of the factors to throw into the mix when you're talking about the options that are available to people.
I think that's a really tough question, and looking in the room, there's some people from the criminal justice system in the room, and I think that this is something that systems have really struggled with, because you say that a woman wants to make a complaint, but she doesn't want the person who abused her to go to jail because it has catastrophic consequences for the family. And so you raise the prospect of a diversion process, and of course that just can lend itself to abuse and influence by the person who committed the offense. And so, you know, the courts, Crowns and police have struggled with these things. Do they lay charges in these situations even when a complainant doesn't want a charge laid? And because there's a greater good in terms of having these issues go to court. And I think it's just a really tough question. And again, if I think about the origins of the Me Too movement, it affords women the ability to bring these issues forward and get redress or a result, whatever that looks like, and that's terrific. It doesn't help a lot of people in the criminal justice system where these kinds of issues are, and I don't really know what the answer is, because diversion's problematic as well.
I think what I hear from your question is that would women's choices of making alternate options rather than going to the criminal justice system, would it somehow put the whole issue under a carpet of some sorts, and or undermine that it's not as important for the... I think it goes back to that whole accountability mechanisms, and then thinking about how, as a society, we are ready to be accountable to these situations of violence that happen around us, and we become witnesses to it, or we are the bystanders who are witnessing it, and what our role is as a whole. So from the legal perspective, I can tell you from the clinic's work, there are many women who come to us who do not want to engage with the adversarial system, and they want to engage with something else, which could be human rights tribunal, which could be criminal injuries compensation, which could be going to the regulatory authorities if the person is regulated, and getting some kind of help and compensation so that they can actually continue with their lives. So there's a huge piece which we are not talking about. There is a health implications which happen when these situations happen in people's life. And as a society, we haven't probably, and we haven't really looked at that piece. So at the clinic, we have professional counseling available, which is not enough because we don't have enough funding and we don't have enough counselors, and the City of Toronto in itself, broadly speaking, doesn't have enough counseling available for the women who experience sexual assault. So thinking about those pieces and thinking about taking it back to that whole trauma-informed approach, that at the end of the day, yes, we should be worried about what is happening in our society, and we need to be accountable, each one of us. But at the same time, in her situation, when she's dealing with it, it should be her choice what she wants to do with it. And if the adversarial system is not working the way it should be working for survivors, for nth number of reasons, we shouldn't be expecting people to be engaging with it. It should be her choice at the end of the day. I hope I answer your question, because it is a difficult question for sure.
I just have a question. Is there anybody here who could speak a little bit about the GLADU system for sentencing? Does anybody know about that? I heard someone talk about it recently. It sounded like an interesting contribution to the conversation, but I wouldn't know how to speak about it.
Hi there. Thank you all. This has been very interesting. I am struck by the fact that until just a minute ago, nobody had actually mentioned the Human Rights Commission and the system of protection for women in the workplace. And the very high-profile cases that we're aware of have mainly arisen within a workplace environment and could potentially be addressed in part through human rights complaints. So I'm just wondering what your thoughts are about using the Human Rights Code and Tribunal, and also what you think the role of the Commission should be at this juncture. Because I think what we're all hoping for is a normative shift that will last, and is that something the Human Rights Commission and Tribunal, have a role in promoting?
To first to Sarah's point, can I say something? To Sarah's point, I think Sarah is making a very important point, I think, and we should all maybe take a minute to think about that the sexual violence against Indigenous women has been an issue way before we were talking about sexual violence in the workplaces, right? So missing and murdered Indigenous women is definitely front and center of this issue, and we should be thinking about that. But while we are thinking about that, and we are thinking about what GLADU reports do in those cases where Indigenous women are impacted and stuff like that, and you would find people who would say that system works well, and you'll find people who say that system doesn't work well. So I'm not an expert of that system. I don't know much about it, so I wouldn't say too much. But what I want to say is that within the Indigenous communities or the immigrant communities, where the communities actually organize themselves for alternate forms of justice system, and they have historically done that, there is a lot of history and a lot of experience and a lot of expertise which is connected to it. To think that we can somehow transport it into a mainstream, I'm not too sure of that, to be honest with you. Coming from a country, I come from India originally. I'm coming from a country which has a lot of alternate means of justice systems. I know that how quickly they've also become corrupt and how quickly they became incubators of power and control within that structure. So I would really think about it. I think it's a very complex and layered conversation, and we should think about it more deeply before even suggesting that we could have some kind of private mediations going on without having a proper structure and proper accountability mechanism attached to it. Speaking to the Human Rights Tribunal, again, I used to practice in Human Rights Tribunal way back, like 10 years back. I haven't really done practice in there, but I know that one of the great things which happened when we made legislative changes, that the statute of limitation got changed, and people can bring in cases for sexual assault without any statute. But at Human Rights Tribunal, we still have a 2-year limit. 1 year limit. So that's something which bars a lot of people from bringing forward the cases. There is also, but there are some great cases which have come out, and there are some great settlements which have been met. And the clinic actually works with the Human Rights Legal Support Center very closely. We do referrals to them all the time in the cases where we identify we can utilize that as a recourse.
I thought I had mentioned the Human Rights Tribunal as one of my options. I apologize if I didn't, because it is absolutely an option that is available to women. There are drawbacks. As I said earlier, there's pluses and minuses to each option. The HRTO is a great option if you fit within the parameters of the HRTO, so you have to be within certain areas. It's not going to be addressing private issues. It's going to be in certain contexts, so there's going to be a choice of whether or not you even fit within that. And as DEEPA mentioned, the limitations issue is going to be a problem, but it might be a problem for some women, but it absolutely is an option. And there is great jurisprudence that comes out of there. Obviously, in addition, in civil litigation, being able to claim human rights damages in civil litigation is an option depending on whether or not you've got the right set of circumstances. That's an option that's available as well. So using the Human Rights Code and the tribunal are definitely options that are available. And again, as I keep going back to the point, it's just weighing your different options that are available to you. No.
I'm curious what people on the panel thought about the recent bill, C-51, I think, and the changes that it's proposed to the criminal justice system with respect to sexual assault complaints, and whether either within the context of that bill or in other circumstances, you've given thought to what kind of fixes might be possible in the criminal justice system that might make it less bad.
I think the changes which are being proposed are positive. I come from a not-for-profit which is always scrambling for resources. So for me, it becomes a resource issue because it's being, like what is being proposed is that there will be access to a lawyer available in certain cases. And I'm like, but which system are we talking about, right? So we actually debuted at House of Commons for Bill C-51, and that's exactly what the clinic's position was. It's great that you're saying that for this one little piece, when an evidence will be introduced, you will have a lawyer available. But why not, A, have a lawyer available for the survivors through the whole process, and B, what are we looking at? Are we looking at legal aid lawyers? I'm not too sure. Are we looking at expanding independent legal advice project kind of a thing and provide representation through those projects? What are we talking about? So I'm not too clear what's being envisioned, but in principle, I think those are welcoming changes.
Just want to say thank you to all the panelists. So this question may be more directed towards Mr. Lisus. And so I'm curious as to whether you sometimes maybe find it difficult to reconcile, for example, a commitment to the Me Too movement with representation for clients like Patrick Brown.
So casual.
The short answer is no. And everyone in this room, or near everyone, is going to be a professional. And if you're going to be a professional, then you have a duty to uphold the ethics of your profession and to discharge your responsibilities as an advocate within the context of a commitment to our system of justice. And so I don't find it a dilemma, because I believe in the system of justice that we have. I believe in the adversarial system of justice. I believe it's imperfect. I believe it can be improved, and things like Bill C-51 make a contribution to the improvement. But as you go forward in your professional development, you will encounter situations which you find challenging and difficult and lonely sometimes, and that is what you signed up for. That is part of the duty that you have to your profession and to the public and to the courts. And there may be cases that you don't want to take, don't take them. Or there may be things that you don't want to get involved in, don't get involved in. But I don't believe that, and I'll speak for myself, those kinds of issues don't prevent me from understanding what I think it is that we all need to do. And to return to a comment I made earlier about responsible journalism, I think that there are some real challenges about the way mainstream or conventional media engages with social media. And I do think it's a problem, and I think it's a problem courts are going to have to work out. If you read CBC versus Lenin, in which the CBC, who I have defended through trial, got into a lot of difficulty because the manner in which they dealt with a investigative journalism piece. This is a constant evolving dialogue. So I think that we're all going to have to go through this together, and I don't have those kinds of issues in doing so.
Okay, so we have 2 minutes left, which basically means time for one more question.
Hi, I'm not a lawyer, I'm a historian, and I'm just wondering, given your conversation that you've been having today, you guys have been saying basically, what I've interpreted from this is that the legal system is really not set up to deal with this properly. That you're dealing with the fallout rather than solving the problem. So I'm wondering, how do we solve the problem rather than just cleaning up the fallout? Or is that just too big of a question to ask here? Because all the things you're putting forward are piecemeal, right? A lot of the legal advice you're giving does not work for people in the working class. It does not work for people who the attackers are not celebrities. Does not work for people that are not in situations where the union protects them or something else. So what is your advice, and how do you see this moving forward? Especially you, Sarah, because I feel that the arts can play a bigger role in this than they have.
Really wasn't expecting that question to come my way. To be honest with you, first of all, I'm sort of astonished, and I'm sure there's a lot of people who don't agree with the idea that the legal system does have problems who aren't speaking right now, because it's kind of shocking that, at least on the surface, there's some kind of consensus about that. Because generally, I'm sort of embarking on a project of looking at this and looking at how lawyers think about sexual assault cases. I've heard just the opposite. I've heard that we have a perfect system, just no woman should ever come forward. Like that's sort of, and I'm not exaggerating that. I mean, if you really dig deep with a lot of lawyers, that's what you're going to get. Like it's a crazy kind of contradiction that happens that I'm tracing back to learning to think like a lawyer, which I used to think meant learning how to be reasonable and logical, but now I realize means sort of distancing yourself from some essential human experience. Just empathy or reality. But good luck to everybody on that journey. I'm married to a legal academic, but that's totally different. So I'm curious about that. I mean, even just the things that Jonathan has said on the panel today and on the phone call preparing for this panel, it shocked me to hear someone who's a criminal defense lawyer say there are gaps. I mean, obviously, while he believes in the adversarial system, he's saying there's a gap. Haven't heard that very often. I haven't heard very often lawyers speak glowingly about C-51. I've heard mostly outrage, actually, among the criminal defense lawyers I've been talking to, that this is like the best system in the world for people who've experienced sexual assault. I've heard arguments that actually the laws are fine, it's the actors within the system, which is what, Elaine Craig's book, I don't want to try to summarize it that way, but she talks a lot about how the actors within the system are not behaving differently, even though the laws have become more progressive. So there seem to be these sort of experiences, but the idea that there are actually gaps in the system is, in terms of that being a lawyer's perspective, is news to me. So I'm really curious to explore that further and to talk to people further about that. But in the meantime, unfortunately, I feel really like this is a time of growth and learning, and people are figuring it out. I think that what the people in the Soulpepper case are doing, what those 4 women are doing, is exceptional in terms of carving out a new option and a new path that we can all look to. It wouldn't have occurred to a lot of people before they did it. I think women are finding their voice in this for the first time. So it's a lot of figuring it out and carving it out, and it's messy along the way. So in terms of like what is the route, from my perspective as not a legal professional, I would feel inclined, and in the cases where I've known people wanting to come forward, it's been my inclination to listen and to try to help figure out what they want to do, and then try to direct them to the professionals who can advise them. But I'm curious I think the legal advice will probably be more useful.
I want to say that from the social location of where the clinic is located, our work has always been, we provide services to the women and work with them and meet them where they're at, and definitely provide very client-centric legal representation and advice. But at the same time, we always have our eyes on the law reform and the policy reform that we need. So we have always done that dance, and we are comfortable doing that dance, and that's what we always strive to do. The situation cannot change unless and until we actually start educating. And when I say educating, I'm saying educating on a continuum of starting educating in our kindergartens to our universities, right? So that's a huge piece of it. This space is a huge piece of it, and spaces like these are a huge piece of it. Sarah talked about After Me Too, which is really amazing. But along with After Me Too, there is a hashtag #UsToo, which has been created for non-status women and new immigrant women who experience sexual assault and violence against them. There is Muslim Me Too, which is talking about Muslim women and their experiences of sexual assault in spaces. So I think there is so many offshoots of the Me Too itself, which is doing the work which we need to do in this, in actually shifting the paradigm. The paradigm shift is not going to happen just through law. Law is one piece of it, and law is growing, right? So that's another thing which is important to know, that when Jane Doe happened 20 years back, we also said the same thing. It's a watershed movement. Right? Yes. And now we are saying Me Too is a watershed movement. The unfortunate thing about it is that we need a lot many watershed movements for this water to really flow, right? So that's where, and I think that's what we need to remember, that the change didn't happen because we didn't do some things right. And this is where I think we have, there is one thing which I identify as a person working within the sector and the movement, is that we haven't done what we are doing with Me Too, and we are striving to do it, is actually getting the men, or so to call the perpetrators, on board, and they coming out and saying that it does affect us too, right? Because think about it, that a man who either is a perpetrator or has witnessed or knows or is a brother or a husband of someone who has witnessed or experienced this also gets impacted. So this toxic masculinity which we talk about doesn't impact only women, it impacts them too. And I think there is a time and need to actually have people come, and I'm really glad to see so many men in the room today, and thank you for asking the question, because I think there is a time has come that we also start looking at how do we include that in this conversation, in this education, and in this change. So I think law is only one piece of it. It is not, the buck doesn't stop at law. It actually starts there.
Time. So I'd like to thank you all for coming, and I'd like to thank our panelists for a really thoughtful discussion.